my watch, but let me see here.
It's a good idea. I'm going to put mine on airplane mode.
Okay, I guess we are live now, and the introductory part of the Congress has already been made. I ask please that anyone that's not speaking to mute the microphone during the presentations. This will help a lot. So, well, welcome everyone to the table topic number 15 of the ABPI Congress. It's a very great opportunity for us to be here today in this interactive environment, which is a new experience to all of us, and is something that we, as close as we can get to the in-person meeting and interaction of people that we can get nowadays. So let's enjoy this opportunity. Today's table topic, we're going to listen to some views on regulatory data protection, its interaction with unfair competition, and what this has to do, or what it doesn't has to do with patents. The first disclaimer that I would like to make to anyone who is listening to us is that we are not going to talk today about perhaps the most hot and trend topic in Brazil, in the intellectual property area, which is the general data protection law, known in Brazil as LGPD. This disclaimer is important because I think since the first day of the Congress, there were some presentations about the general protection, data protection law. which protects personal data. And today's approach will be different. We will be talking about regulatory data protection, the data that is submitted to the regulatory agency to obtain the so-called marketing approval and the right to manufacture and market and commercialize drugs in Brazil. More specifically, today's speakers will share their views on the regulatory data protection, which is submitted to Anvisa, our surveillance health agency in Brazil. They will talk about the data protection, their views of data protection and in Brazil and abroad. And for this purpose, we have three speakers today. We have Marta Peña. She has an extensive and impressive curriculum. She has worked in the pharma field since, I guess, 2000 or before that, has held high and important positions in companies in the pharma sector. She's not a lawyer. As far as I understand, she went to medical school. So it will be very, very interesting to have her view, because we also have two other speakers. There are lawyers. Fabiano Andreatta, he is a lawyer and is in the pharmaceutical legal area for more than 20 years, has worked for a few big multinational pharma companies during his career. And the last position that he has held is the legal and compliance. He was a legal and compliance officer of Behringer. Finally, and the reason why we are having this today tables topic in English is because we have a special guest from the United States, from Indianapolis. His name is Craig Tucker. He's patent counsel at Eli Lilly for the last 20 years. He handles global procurement, portfolio management, international IP enforcement, and IP advocacy for Lilly worldwide. He is also a biologist, as far as I understand. He studied biology and biophysics in the Purdue University, and afterwards graduated in law as well. So the first one will be Craig. Craig, you're welcome to share your presentation.
Thank you very, very much, Luis. I'm very honored to be able to be in this panel with my colleagues and talking about a very important topic for pharmaceuticals. Of course, we have, so I am the Regional IP Counsel for Latin America for Eli Lilly and Company, meaning that I'm responsible for the general advice on intellectual property for all of the LATAM countries. But I've had an extensive career in patent procurement, portfolio management, and global advocacy. Let me see if we can make sure that I can share my screen and we can see the presentation. Okay, Luis, if you could confirm you can see my slide.
Yes, now I can. Yeah, go ahead.
Okay, very good. So do you see the one slide, or do you see the slide in the next slide view?
We see just one slide. I think the first one.
Okay, so the very important disclaimer. Let me see if I could, there we go. Okay, so for the purpose of this presentation is to provide education and informational content and is not intended to provide legal services or advice. Very importantly, these views are mine. The other statements expressed are my own views as a presenter and do not necessarily represent those of Eli Lilly and Company or ABPI. And so with that, I would like to title up this portion of the presentation, the regulatory data protection. What is it and where can we get it? Protection against unfair competition or unfair patent extension? This is the debate in the public at this time. First, I'd like to do some framework of what is the pharmaceutical development cycle and why is intellectual property important at all, and what are the main things, half of which is regulatory data protection, which we're going to talk about today. And this slide is probably fairly familiar with most people viewing. It's the basic rocket ship view of the development of new drugs. And the next 4 or 5 slides are actually from a presentation I gave last year about the pharmaceutical industry and intellectual property in general. And the point of this is to observe that the discovery process is very long and very costly. About 10 to 20% of the costs are upfront at this point of the development, where we'll screen in an innovative company 10,000 or more compounds to get about 250 or so compounds that would be designated as preclinical, meaning that they have the activity, and we're now screening to find the one that's going to get into the clinic, one that is showing enough promise not only in basic screening activities, but also looks like a drug might go forward. Out of those 250, we narrow those down to you might get 5 compounds that will actually enter the clinic. And by this time, you sunk about 20% of your costs into development. During the clinical trials up to an approval, you're now getting into the very expensive realm. And about 1 out of those 5 are going to end up being able to be an approved drug. And so by this time, to get one drug to market, typically you're going to spend 1 to 1.5 billion US dollars for a small molecule and 2 to 2.5 billion dollars for a biologic. The timelines are enormous. For the small molecules, on average, they tend to be about 8 to 12 years. Of course, there's great variability, as we've seen in this COVID, where, oh, how did we get therapeutics almost in a year? This is amazing. This is unprecedented in our industry. And a lot of that is because the position those molecules were already in because of the intellectual property that was in place beforehand. That's a different story for another time. For the biologics, the timeline is even longer, 10 to 15 years to get one approved product. And only about 1 to 2 out of 10 approved products are going to earn enough of the investment to recoup your investment cost and be able to fund the next cycle. So given these odds, I ask you the question, would you roll the dice with your money? Those kind of odds, that kind of risk. Those the question that the pharmaceutical industry always has to come up with, yes, if we're going to have new drugs. Let's compare that now very quickly with the generic biosimilar scenario. I'm going to first point out this one right here. The profitability is guaranteed. You already know that the reference drug is successful, does what it's supposed to do. Otherwise, the biosimilar and the generic aren't going to develop it. You also find out that within about 6 months of marketing, you're going to have 70 to 90% of the market in most of the major countries. Your costs of development are going to be about $1 to $2 million for a small molecule, more for a biologics, but this 100 million is still a shadow of the $2.5 billion required to get the biologic to the market as an innovator drug. Your timelines are also much shorter. Instead of 8 to 10, 12 years for smaller molecules, you're looking at 2 to 3 years. Why? Because you already know everything. It's already out there, and you're now just following along in the footsteps to show that you can do the same thing instead of a new thing. So for that, then, when you know that you're an innovator, you have to sync these costs with this probability of success to know that you're going to lose your market as soon as when generic is available. Now, will you roll the dice? So you can see just exactly how important it is to have some sort of protection for the new products. So if not, you won't have new products. You have to be able to combine great talent, skilled in a wide range of expertise, facilities, materials, administration, and other resources, sustained for a long period of time with no guarantee of success. If you are once successful, then you have to have in order to get subsequent cycles in innovation, you have to maintain that critical mass, that inventive environment. Otherwise, it just all falls apart and you start from square one again. Thus, the investment risk that brings the new medicines should be timely rewarded and enough to incentivize and enable the reinvestment again and again to keep the cycle going. So we see then, how can we do it? Well, there's two proven ways to allow for the natural flow of rewards from those who can, so they can again. The reward generators of the intellectual property in pharmaceuticals. One is patents that we know. Another is the regulatory data protection, which we're talking about today. And I'd use this slide to briefly show some of the similarities and differences. We're going to get more detailed in there, but for the sake of time, I need to move along. The point is that this method, whichever method that a country uses to be able to get this reward back to the generators of IP so you can keep it going, it needs to reflect the average time needed to recoup that investment, or different perspective, complete the next cycle of innovation, maintain that innovative environment so that you keep things moving and you don't have to recreate each time. So let's turn now to that regulatory data protection, because we're all very familiar with patents, how they work. The patent you get when you invent. You file your application as soon as it's ready for patenting. Do you have a drug product yet? No, you don't have a drug product yet. It's going to take you 10 to 12 years, and somewhere along that you filed your patent and started a 20-year clock at that point. And you don't know if you're going to have a product before that 20-year clock runs out, because how long does it take? 10 to 12 years and longer for the biologics. So oftentimes you're pushing that clock. Will you have any market exclusivity? You don't know, because you don't know if you've got a product when you file your patent. So how do we get into this regulatory data protection system, which is different? Originally, for the regulatory schemes, an innovator would develop their dossier to prove that their new product is safe, it's effective for what it says, and you have manufacturing and supply chain controls in place so that when the drug is presented to the patient, you know it's safe and effective as reported. Well, after the patent's expired, everybody's free to use it, right? Well, there's a hurdle. That data that you use to prove that is your confidential information and nobody else can use it. It's given to the government only for the purpose of proving that it's safe and effective. And so if somebody comes along after the patent's expired, they used to have to present their own data from their own clinical trials to support their product, even if it's a copycat. Well, it didn't take long to see that the generics and lower cost medicines were not getting to the market anytime soon after the patent expired. And this didn't seem right. And so people were asking, well, why do you require, as a regulatory thing, the other companies to repeat expensive, long studies in order to just duplicate what you already know? You already know that it's safe and effective. Well, isn't the regulator's job done if the follow-on just shows that it's the same drug, it's equivalent? Much simpler prospect, much shorter time frames. You can get competition going at the end of the patent term right away. So why do the regulators need to do this? So lower development costs also. So those generic drugs ought to be lower price, and you can get greater security of availability around the world because you have a lot of manufacturers who now can do it. It's reduced to a commodity at that point without the regulatory hurdle. Just reference the prior approved drugs data package. We have a problem though. That problem is that the innovator only disclosed that data to obtain approval. That's their trade secret. It's held in trust by the government, not to be used for someone else. We're the ones who invented it. We're the ones who put $1.5 billion in to develop it. Why should I now give my data away? So there's a tension there. Next slide. So what about unfair competition? That sounds like it's not fair to the innovator. Unfair competition is a broad spectrum of business practices. A common theme is that it gives an unfair business advantage to an entity over another. And one type is clearly known and designated misappropriation of trade secrets. What's that? Trade secrets, as everyone knows, is anything that derives independent economic value that derives that value by being secret. It can't readily be obtained from somebody else. And somebody does get a hold of it, they can then, by its disclosure or use, they can get economic value from it. And the second wing is that it's subject to efforts that are reasonable under the circumstances to maintain the secrecy. So doesn't a regulatory data package seem to look like, yes, it's a trade secret and it's held in confidence by the government? How then can a government use one company's expensive, hard-won, confidential information to permit the direct competitor onto the market and not be government-sponsored or assisted misappropriation? There's a tension. Or is it a government taking without compensation because the innovator wasn't paid by the government for their data? So how do we do this? Well, a counter theory would be that it's government's job not to worry about confidentiality, trade secrets, things like that. Our job is to review, regulate, is it safe and effective? Give them a marketing authorization. If it's not effective, don't give them a marketing authorization and don't get into the intellectual property arguments and things. So don't we have a job to do, and we're doing it if the follow-on just says, there's my proof it's safe and effective. Here's my proof it's equivalent. So go ahead and give me my market authorization because you have no reason from a regulatory basis to deny me. Let the courts worry about intellectual property. The counterpoint, well, isn't approving for market on a two very unequal sets of requirements. The innovator, you require to produce all this data. They have to go out and spend the money, spend the time and effort to prove and get the data. That's one set of standard. And then you get a second, much lower standard of just prove that my product is equal to his. Now let me compete equally and directly with them. So we have lots of counterpoint, but it sure looks like it's going to be either a government taking or a government allowance of misappropriation of a trade secret. I'm going to skip this part here and just say that as for the government's hand, take a look. Isn't not gaining a direct economic benefit from sponsoring such a system? So the government gets is that a conflict of interest for the government? Yes, it's a public good to have a lower price and whatnot, but we're talking about unfair competition, and isn't making a system where you have a conflict of interest and I'm making the rules, is this not also an unfair competition issue? Or a government taking without the compensation? So now let's enter into TRIPS. And this tension boiled up and was this hot debate subject of lots of the TRIPS discussions. And TRIPS Article 39.3 puts an obligation on each and every WTO member that they are required that if, as a condition for approving the marketing of a pharmaceutical or agricultural chemical entities, the submission of undisclosed tests or other data, the origination of which involves considerable effort, which we've shown, shall protect such data against unfair commercial use. In addition, members shall protect such data against disclosure except where necessary to protect the public. And this isn't in the manner of economically protect. This is in a matter of danger of false goods to the public, things like that. So that kind of protection. Or unless steps are taken to ensure that the data are protected against unfair commercial use. Notice a couple of things. The unfair competition law defines use of a trade secret as unfair competition. You don't have to see the confidential information. You don't have to disclose the confidential information. It's also the use of the trade secret is unfair competition. Notice also that the article itself does not mention any timeline for the expiration of the data owner's right to protect against unfair commercial use. So all of that timing was part of the background consensus we're in. At the end of the day, Article 39.3 allows the countries, or it's understood that the countries can and must implement legislative limits on the time periods for RDP. And that would then allow them to, after that period of time, allow the referencing of earlier approved drugs to prove up the safety and efficacy of a follow-on, and thereby let a competitor in. So what do we have? Let's take a closer look then again at the regulatory data protection and patents. The regulatory data protection protects the data per se. The patent protects the discovery through the product development of the marketing. As long as it lasts, it protects the invention itself. And it is protecting the invention in whatever embodiments that you happen to find it in. This data per se protects just the value of the production of that data. It doesn't protect the subject product that the data pertains to. So it covers also only the proprietary data required to be disclosed for the marketing authorization. So it's very delimited in its scope. Proprietary data, not publicly previously disclosed data, and only what's required in order to get a marketing authorization. The RDP is a statutory period starting at the marketing approval, and that mitigates most, but not all, the access to the market risks. There's further access issues later on, but that's a different topic as well. But the important point is that the RDP starts with the marketing authorization. When did the patent start? The patent started at the discovery with the filing of the application, 20 years, and it's done, regardless if you ever made it to the market or not. So the RDP represents a market exclusivity that actually protects your the early ability to market the drug within a country. You get the marketing authorization, it starts. You have this long, innovator, to supposedly recoup. You will not have a generic, a direct copy, but it only protects against the use of your data. If somebody else comes along as a next in class, a similar product, and they have their own data, they can be a direct knockoff copy with their own data, and RDP will not save your market. They can get a marketing authorization. You'll have to rely on patents at that point, which may or may not have expired already. So that's the difference between these two, RDP and patents. Now, let's point out how they are not the same and how they are not extensions. Neither of them is dependent on the other. The data is the data, whether it's covered by a patent or not. You get your RDP period for filing that data as an MA, and they can't reference that. The patents, on the other hand, doesn't have anything to do at all with the regulatory data protection period. The patents run from the filing and they expire according to that date and that date only. It has nothing to do with whether you've filed it. If you file your marketing authorization dossier, it doesn't extend your patent. And likewise, whether or not you get a data package exclusivity has does not affect the expiration of your patent. So one will, in fact, extend longer in time than the other because they are separate. And so protecting the product, but which one expires last is purely dependent on its own circumstances. They can both run concurrently if the patent has not expired prior to the MA approval, but the extent of the exclusivity of the market is theoretically the same. So it should be 100% protection of the market of the covered product. So what product is covered by the marketing authorization? You can't use the data. If you can't get a marketing authorization without reference to your data, then they're not getting on the market. Likewise, the patent, if you come under the scope of a patent and the patent hasn't expired, you shouldn't be able to come on the market, but there's problems with enforcing it. Now, without linkage, RDP is easier to enforce because its government controls the approval of the follow-ons, whereas the patents must be pursued in the courts and often only after there's been market entry. And we showed already that within 6 months of market entry, most of your market is gone. The price is eroded and you will not get it back. You have now suffered irreparable damage that you'll never get back. So that shows us the importance of the RDP. And with my last minutes here, I want to now say, where can you get it? Where in the world has RDP and where is it still not available? So here I have a color-coded map here for us. And I have down on both sides here listed, hopefully flowing with the maps themselves, the areas that have regulatory data protection. Those that are grayed out, I wasn't able to find information about. But we start off with the very nice dark green Europe. They have a 10 and +1 regime for regulatory data protection. One of the things that the innovative pharmaceutical industry is well aware of and is starting to use for that, do we roll the dice and put the money into this compound? Well, since Europe, the US, and Japan make up a vast majority of the pharmaceutical market, and if they can afford to, they'll build their business model off of, we're going to get 10 years of market exclusivity for our data. And the generics tend not to come along and do their own. So we're only worrying about Me Too compounds in the same area, not the knockoff compound. So if we can depend on 10 years there, that's a huge benefit and incentive to do it at all. Also, since you have that, guess where a lot of those pharmaceutical companies are? They're based in Europe. The next place we see is in the United States. Now, United States is odd in that it has 5 years for the data package exclusivity for small compounds, but 12 years for biologics. So that's why we're coded in blue here. Where are an awful lot of pharmaceutical innovators headquartered and doing research? Good protection. We can build a business model that is sustainable and we can get the investment back out and pay it forward to next cycles there. Some of the other countries in lighter blue or in green, Canada and Japan, have 8 years of data package exclusivity. Russia, Turkey, and some other countries have 6. The majority of the other countries in yellow have 5 years of data package exclusivity. In Mexico, they have 5 years, at least 5 years, which is defaults to all of the small molecules, but there's ongoing litigations and things to see that biologics do take longer. They should get longer protection. The statute does say at least 5 years. And so the arguments are going back and forth and trade agreements are being negotiated, wondering whether or not using a longer period of time for biologics would be there. We see, of course, and the reason why it's such a topic here in Brazil now, that Brazil does not have data package exclusivity. So an innovator a follow-on As soon as the innovator is on the market, they can make their copy, they can submit to Anvisa, they can get a marketing authorization right away. And then it's up to the patent enforcement efforts to see whether or not that's going to launch and how it's going to play out. There isn't a clear demarcation that the innovator has at least some period of time to recoup that. The last thing in saying before passing it on is that, again, ideally for sustainability of innovation, you need to have some sort of very strong intellectual property enforcement so that the innovator's investment can support the recoup of the investment, the paying forward to another cycle of innovation. Regulatory data package is one scheme that does that by allowing the government to either grant or not grant a marketing authorization based off of the innovator's data, which is actually a trade secret, which could come under all of those theories of unfair competition. And with that, I will pass it on.
Craig, thank you so much for this clear presentation. It was very good to see how challenging and risky and expensive the R&D field is, how much money and also how long a company must dedicate to search, to seek new drugs, innovative drugs, and the importance of regulatory data protection for to encourage those players to move forward.
You have to support a lot of people for a long time. And
for a long time,
whether or not you're going to afford to do that is a huge question.
Yes, and always remembering that this is, of course, the companies are doing it as business, but also aiming at the patients. In the end, it's the patients that will be benefited from that. And thank you also for the basis for explaining to the audience how the regulatory data protection works. Regulatory data protection for drugs for human use, and how it is applied, and also more as important, and the difference between data protection and patent protection. This is also very, very relevant for the discussions. And so thank you again. I will let the questions for the end of the presentations. Regardless of that, anyone may send the questions in the chat in the meantime. And well, our next speaker is Marta Pena. For those who joined a little bit later, Marta has a long experience in the pharma industry, either in the R&D and big pharma companies, but also currently and for the last decade inside a Brazilian big pharmaceutical company. And it will be very, very interesting to hear Marta's view on that, and how challenging it is for a company like Europharma and for any other Brazilian company to migrate to innovation, to seek this path of innovative drugs, and how the regulatory data protection fits in. So Marta, welcome, please.
Unmute. Yes. Sorry. Thank you very much. Thank you for the invitation. It's an honor to be here. Thank you, my colleagues of the table and all the audience. As Luis said, I am not a technical person, so I'm a physician. My background is in medicine, and a long period, more than 20 years in a pharmaceutical company. So in the multinationals, either multinationals or right now in a Brazilian company. And why a medical person was invited to discuss a technical issue in a technical Congress. And for sure is not to give a technical presentation, which Craig has already given us a bright presentation. I learned a lot during his speech. And I am right now a vice president for innovation in Europharma. And sure, the invitation was because Europharma has a almost, I would say, unique position among the Brazilian pharmaceutical companies right now, which is to support data protection and as a way of protection of intellectual property. And I think that the most interesting here is to talk why that shift, because it was not always like that, and why we made that shift in our position. I think that is the most interesting speech that I can give to the audience. And to talk about that, I have to talk about strategy, because this is a question of a strategic alignment. And it's not because we are good or bad that we decided to support data protection. And I assure you that that was also a huge debate in the company. We've been talking about it and debating the association, etc., and it was a long debate inside the company. So Europharma is national capital, is a Brazilian capital. It's a Brazilian pharmaceutical company with more than 50 years, more than 40 years, almost 50 years in the market, that born as a CMO, manufacturing products for other companies. With time, it migrates to a company that manufactured generics and actually copy of other drugs. And it has been growing very fast the last 20 years. And throughout the last 20 years, we've been growing double digit year after year, sometimes high double digit. And manufacturing, formulating, manufacturing, distributing, marketing, mainly branded generics. More or less 60 to 65 of our revenues come from branded generics. But when we looked at the scenario on the market and we started to make strategic discussions how to continue to grow, we look at this, a situation where we do not manufacture APIs. So we depend on APIs on other manufacturers. And to grow, either what should we do? Compete with the big generic companies that manufacture APIs, or what should we do? So we decided for two main strategies. One of them is the geographic expansion. Nowadays, Europharma is a regional company. It covers the whole Latin America, and our decision is not to stop there, is to continue to grow outside the region. And a second strategy was to innovate, because imagine we acquiring APIs from another company, trying to compete with this company in a market like a US or in a market. So our decision was, if we want to continue to grow in a nice way, and perpetuate the company for perpetuate the company, we really need to go outside, and we need to manufacture and discover our own products. Not necessarily manufacture, but to discover and put in the market, go to the market with our own products, or better saying, with protected products. And this is a very important differentiation. I'm not talking about patented products. I'm talking about protected products. So we started this journey to start to construct a pipeline of innovative drugs. And we do that either through incremental innovation, partnering with other companies in licensing products or co-development products. And also we started our own process, our own project in discovery. So right now we have a discovery program where we are, for the last, let's say 7 years, we started to this program to make our own molecules. By now, we do have a very nice pipeline composed with those different pillars of innovation. And we think that we actually start to launch a few products this year and next year. But when you go to a journey like that, moving the company from a pure company-based model based on copied products, and move this company to an innovative company, this is a huge change, huge transformation, which impacts the whole company. We are not talking about one project, two projects. We are talking about a company that wants to have a sustainable model based on innovation. And as we saw it in Craig's presentation, this is a long-term move. This is not for tomorrow. This is not for next 5 years. This is a really long-term move. Second, this is a risky move because, as also we saw at the Craig's presentation, a lot of, even when you're licensing in phase 2, in phase 3, sometimes even when the drug is in the market, you lose your investment because it fails. And so it's really risky. And last but not least, it's costly. It's a lot of investment. We are not in position of invest billions, but we are right now, as last year, we invested 8% of our net sales in R&D, not all of them in innovative products, but as year after year, we increased the amount of investment in R&D, and we increased the percentage that is dedicated to innovation. It's a lot. It's a lot for a company like our company. And when we did all that and we start to make the movement in the company to change culture, to change the way we see things, we also start, of course, to discuss how would we protect our investment. And as Craig said, how we are going to be rewarded on the investment that we are doing. And it's also important to say that we are new. We are the new kid in the block trying to make its own products, licensing products in early phases, not yet in the market. So it's even maybe worse than that, Craig said, that companies take to 8 to 10 years in a small molecule, 10 to 15 in a large biological molecule. We know that it will take longer time, even longer time for us, because we are going to make mistakes, etc. So it's critically important to have the return on the investments that we are making. But we are still a generic company at the same time. So we made the calculations. We put on the spreadsheet what we would lose, what we are going to gain, what are the positive impact or the negative impact of data protection if we support data protection. Because at the end, you know, it's a question of make the right calculations. And when we did that, with the pipeline in hands that we have, a pipeline of, and future pipeline for generics, a pipeline for innovative drugs, and we made the calculations, we discovered that for maybe 5 years, we do not lose, we do not gain anything. It's balanced. But in 10 years, we start to gain. And the positive impact of data protection, it's clear for us. So it's really a question of alignment and return on investment on what we are doing. Is there any other company? Eurofarma is the only company in Brazil that is supporting, when I say in Brazil, I mean Brazilian companies. As I am on vacations, when I left for vacations, there was another one company that also investing a lot in innovation, that also supports innovation, but that is not, I'm very curious about that, because there are another couple of companies in Brazil trying to do the same movement. And only 2 of them, Eurofarma and another one, are supporting data protection. We had lots of discussions, and I can only guess why. Maybe the companies are not investing as much. Maybe they don't think that at the balance of what they gain, what they lose, at the end, they are losing more than gain. Maybe they don't believe they're bad, I don't know, or they don't think it's going to be so representative as our ambition is for Eurofarmas. What I mean is that I don't think it's a question of good or bad, as I said, but really a question of strategic alignment. And I think that for the pharmaceutical sector in Brazil, the move towards innovation, I think, is the right bet. And I think there are a couple of companies that are in the position to make that bet. And I think that all of them, including the ones that are not supporting data protection, would gain more if they do that. I think for the long term, and we need to do that. We need to do that move, and we need to, as a sector, to really make this move towards more innovation. Another point that I think is too, I want to highlight is that not having a clear regulation is very bad, because then it's open to discussions at court. I think the worst position that we can have is not having this regulated properly. There was problems in the past. I know at least one company that is against exactly because it had problems in the past. And the discussions that we have was, but if there was a regulation in the past, we are not at that position of discussing that at the court. So I think that no law is very bad. No regulation is very bad. So in summary, that's what I have to say. I think that I use, I don't know how much time, but it's what I want to state for the audience today. Thank you. Thank you very much.
Thank you, Marta. Thank you very, very much for your presentation and for sharing those important that important view of someone that is inside of a company, a Brazilian company that is targeting innovation, that according to you is, as you said, a forma, and I believe that most of or every other generic company depends on the supply of API, active pharmaceutical ingredient, from other countries, from other foreign companies. And we've seen how dangerous it is during a pandemic time to be in a position like that. So I believe that this last months were very encouraging for all those companies to see and review the importance of producing in Brazil the API, and to seek new drugs to invest. And on the other hand, I know, as you said, and companies need to balance the investment in generics that is currently paying your bills, and the investment on innovative drugs and the necessary clinical trials for the company to obtain the marketing approval before Anvisa. So, but thank you so much. Thank you so much for stepping in, and we as Brazilians, we cheer for Brazilian company to succeed, to have a strong R&D portfolio, but as you said, we need to establish a fair and clear legal regulatory system, and perhaps, I don't know, perhaps this is still lacking under the view of some, and that's something we need to encourage our legislators to do. Now we have our third and last speaker of today's table topic. His name is Fabiano Andreatta. As I said in the beginning of our table topic today, he has been actively working in the pharmaceutical field inside the compliance and legal department of those companies. He has he advocates the importance of the regulatory data protection in Brazil. He lived and lives the hurdles to have regulatory data protection enforced and recognized in this country. So Fabiano, please, you're welcome to share your view with us today.
Thank you, Luis, for this introduction. First, a little bit disclosure. Besides Boehringer, I also worked for Novartis and Eli Lilly and Company for the last 28 years, both in the human pharma products and animal health products. Regulatory data protection would affect both worlds. So, and here starts, I would say, our journey into memory lane here, because we have to explain the uniqueness of the Brazilian IP environment. We started like in '94 when Brazil introduced the TRIPS agreement into our legal frame with no exceptions at all. And data protection was already present there. In '95, when Brazilian Congress enacted our intellectual property law, the regulatory data protection was also there, but on fair competition provision, meaning, and this is actually the statement in the law is that it's unlawful, it's a crime in Brazil to use another person data without their consent. And here starts the problem, because Brazil, when enacted that provision in our IP law, didn't put a time frame for that data protection in there. So basically, what the law says in Brazil is that we have a forever protection on any of our data. So the bizarre stuff starts there. But at that time, I mean, the pharmaceutical companies started to, apply for patents in Brazil. There was a huge increment of investments in the country. Everyone was absolutely happy. But the problem then that those companies were facing was, okay, we also started clinical research in Brazil and produced a lot of data that we have submitted into our dossiers. At that time, a patent approval was taking 4 or 5 years. That was late 90s. And most of the people in this event knows today INPE's backlog is like 12 years to approve a patent in Brazil. So there's a lot of discussions on that side, but that's another topic for another occasion. But at that point, and this was late 90s, early 2000s, Brazil was also facing discussions within Mercosur regarding the protection of data regarding animal products, specific with Argentina. And that was also important for Brazil because, as a lot of people know, the agricultural business is a third of our GDP. So it's a very important sector for our economy. So in the year late 2001, early 2002, the Brazilian government decided, no, I will regulate regulatory data protection. I will grant protection administratively to companies that submit data regarding animal health products, agrochemicals, and pharmaceuticals. That was in the first provisory measure that was enacted by then President Fernando Henrique. The problem there increases there because in the eve of the approval of that measure in Congress, magically, and this is facts, I mean, I'm not making up this, the pharmaceutical products were taken out of that legislation. So the next day Congress approved it, they regulated regulatory data protection for animal health products, agrochemicals, but not human pharma products. So we have that situation in our hands here in Brazil, how we are going to enforce the protection of our data. Because at that time, Anvisa was granting all sorts of copycat registrations, and we realized that there was a huge, backside negotiations on those years, etc. So most of the companies went to courts in Brazil to get at least some protection of our regulatory data. And those companies never ask the courts, give me the forever protection that's is in the law, but let's try to apply the same standards that the animal health products has, 8 to 10 years, depending on the products, or the standards that other country uses, like the EU, the US, or Japan, which is, as Craig explained it, I mean, it's fair, it's 5 to 10. So there was actually nothing new in there. The problem is that at that time, that was 2002, 2003, first courts didn't actually understood correctly what regulatory data protection was. And as Craig pointed before, there was this huge misconception that regulatory data protection was trying to extend the validity of patents, so it was a nightmare. It was a PR nightmare. Courts didn't understand, judges didn't understand, and we had part of the Brazilian government against that, specifically the health ministry that was at that point very against intellectual property for pharmaceuticals in Brazil. They litigate hardly against that. And so at that early litigation, we haven't had success in actually explaining the case to courts or to the Brazilian public. But no matter what, till this day, we still have those same provisions in our books. There is no change at all in the Brazilian environment, regulatory environment. What changed now is first the political environment and the regulatory frame. Because right now, people are starting to understand the importance to have protection of data. And not only for the pharmaceutical companies that do clinical research, but also for local entities in Brazil that are starting actually to produce science and produce very good data in several different fields. Petrobras, Embrapa, a lot of universities, companies like Europharma, and there's a very big number of companies that now do research, understand that they need to be protected because now the competition in the market increases because Brazil is as a WTO member is as open as we can to foreign competition. So today, this time frame will be interesting to start and remember the country and remember the governments and remember the courts that regulatory data protection is not patent. Regulatory data protection is not a kind of blocking mechanism on newer competitors, because as Craig explained it, and we have right now companies that produce their data. They don't need anymore to rely on data of others to ask for their registrations. There is today a much more clear process that specific data have a value and have to be protected. One thing that we are now learning more is that with the animal health products and the way MAPA is handling data protection is actually a good example to other companies that, okay, it's no big deal. The government can do it. It's already being done, and in the agricultural business, I mean, there's a lot of generic companies, a lot of generic products, and they understand that they have to protect that specific data that each company produces. And those are Brazilian companies that are doing that. In these last 20 years, trying to explain regulatory data protection in Brazil, I would say we have ups and downs, a lot of downs actually, but today I believe that we have a very good environment to actually go back into the government and have a clear negotiation in how to implement that also for pharmaceuticals. And more than that, because right now we are seeing also in the pharmaceutical business, the value of the incremental research. We are now are seeing older products that are already generics in several different industries that companies in Brazil can do research and do and invent new uses, new indications. So they are producing these new data, and they can protect that in Brazil. That will support Brazilian companies, the Brazilian people, and the Brazilian economy. One of the things that the pandemic is actually teaching all of us is that you cannot rely in one source only to solve all your problems on the pharmaceutical area or in the medicine. If companies in Brazil can also do research, and a lot of universities are actually doing research in Brazil for like the Zika virus, as we remember right now, dengue virus, and also right now for different compounds and vaccines for COVID-19. I mean, they are now starting to learn the value of that and why that clinical data is important. So today, I would say it will be much not easier, but it will be much more clear to explain to Brazilian stakeholders that regulatory data protection is not an abuse of anything, is already in our books, in laws, and it's compliant with Brazil's obligations into WTO. So it's not something we are taking out of our pockets and putting on the table right now. It's already been used in US, Europe, and Asia. So if companies cannot start, discussions with the federal government on that, and had, to pursue again litigation in courts to actually protect those dossiers, this will be a very good time to do it, because we have now a different, I would say it's a new word. I mean, people are now learning the importance of knowledge, the importance of these kind of data that are produced not only in Brazil by national companies, but by multinational companies, by academia. And so today I would say the pharmaceutical industry will have much more support in a sense that discussions in courts can be less emotional and more rational. Because for many years, for us that have worked in intellectual property in Brazil, intellectual property discussions were very emotional. Today, I truly believe that now these discussions are not emotional anymore. Also because, for example, we now have biological entities that are much more complex products to manufacture, to do research. And the health ministry actually understands that the biological entities now are not the same as synthetic ones. And so they cannot give a Me Too registration based on interchangeability, because they are not interchangeable by themselves. A live being is totally different from another. So that discussion, I would say, is much more mature to actually go back, even in associations like ABPI or Interpharma or Sindus Pharma or ABPI, other entities, and with the government, in order to rediscuss the frame of regulatory data protection, because the pharmaceutical industry is the only one here putting out of the legal frame in order to get its research protected. So protection of research is fundamental to any economy or to any country that do wants to thrive and do need to grow. And we need to grow a lot because we're coming from a huge recession, and we have a lot of people to feed, we have a lot of huge unemployment, and we have to grow our economy as big as possible. Those were, Luis, those are the historical facts and arguments that I would like to put into our discussion. Thank you.
Thank you, Fabiano. Thank you so much for telling us, to sharing with us and the audience this historical background of data protection or unfair competition in Brazil. So before I open to questions, eventual questions of the audience, just a quick comment. As we saw today, Craig set the basis for this discussion, brought the conceptual and theoretical aspects of this discussion, shared his views. Right afterwards, Marta gave a wonderful testimony of how important this data protection, regulatory data protection is, and how important to solve all the doubts surrounding this protection in Brazil is for any company, especially for companies that are migrating, that are targeting innovation, and that will submit or are submitting data of clinical trials to Anvisa. And finally, Fabiano, he got into the details, the intricacies of the discussion in Brazil. That's because he's for a long time dealing with it, experiencing, living this discussion in Brazil. And Fabiano, it's true. I can personally say that in fact, unfair competition is provided by our law, but not only unfair competition as a general concept. Brazil is a member of TRIPS agreement, and because of this fact, Brazil enacted a law, the Brazilian Industrial Property Law of 1996. And Brazil, following the guidelines of TRIPS agreement, included in the law the protection for unfair competition, and specifically in Article 195, Section 14, the protection for regulatory data that is submitted for the health authorities in Brazil. And it's also true that unfortunately the legislators forgot to set the term of such protection, and that has been causing issues to those who seek this protection. And the way out, the alternative for those companies that want to protect regulatory data protection in Brazil was to sort of apply an analogy to Law 10,603 of 2002. And because, as you said, this specific law that in the beginning, as a provisional measure, as a bill, provided protection for humans, for drugs for human use, suddenly deleted this excerpt from the bill and provides protection, time-limited protection for veterinarian drugs, for fertilizers and agrochemicals, and those areas are benefiting, are encouraged to research, to develop, to produce the data, and then submit it to the authorities. To this, so thank you so much for sharing this historical and detailed facts with us. And well, let's see if anyone from the audience has any questions, I'm going to see here the either the people that is here interactive with us. We can see your names. So if anyone has questions, please raise the hands or open the camera. If not, let me. I can perhaps make a question. Yes. Although the presentations were we have 10 minutes to end this table topic, but yes, Craig, please, Craig.
Yeah, if while we're waiting on others to formulate questions and to add to the broader discussion, I just wanted to point out how Martha and Fabiano have, seen that and validated that Brazil is starting to reap the benefits of a stronger IP regime, and that they see that in order for that transition from just simply copying to actually innovating and contributing to the advancement of medicines, the advancement of agricultural products, the advancements of these things, when you protect them, they come to Brazil. Brazil then has some place for their good students who are, their universities are starting to put out many good minds trained to innovate, trained to advance science and the arts. But where do they have jobs in Brazil? Right now, they all go to Europe or America or somewhere else to find the jobs because there's only academic jobs in Brazil. Now we're starting to have many more companies, and so you're seeing the slow growth, and it can be accelerated tremendously, as Martha had pointed out, if you have certain protections that allow you to that are commensurate with the length of development cycle. So the match of the protection needs to somehow cover that period of time so that the innovators can keep innovating. And then there's a place for the generics. There's a place for the biosimilars. That's the way it's designed to work. Then they can enter and you can get reduced prices and things. In electronics and other industries, it works the same sort of aspect. And other companies can use what has already been developed and copy after the patents have gone, while the innovators continue to advance. So I thought and it's very exciting to me. Interpat has put out a paper about the value of innovation to the Brazilian economy. They also before put out one to the Argentine economy, comparing it to other countries with stronger IP, but similar size of economies and population. So it's very exciting to see that, yes, those theories have reality, and we're seeing it in the growth and development of Brazilian innovation, Brazilian companies taking leading roles. So I think that's fabulous.
Thank you, Craig. Thank you so much. Our audience is a little bit shy today, so perhaps, okay, finally we have a question from Ana Carolina. I was going to make mine, but I have already spoken a lot. So her question is to everyone: do the protection to be afforded for data could also foster the growth of clinical trials industry as well? Could this be another benefit too? So this is an open question for anyone, Martha, Fabiano, or Craig. I don't know if you have access, but I can repeat it on the right side of.
I can answer. And
okay.
I can understand. Actually, clinical trials is part of the development. So, and I think that as a company that is trying to enter this world, We have a lot to improve in Brazil, from tax related to innovation through bureaucracy to import issues, through how do we deal and the velocity that we deal with clinical trials and intellectual property. All that must improve to the sector improve together. I think that is part of it. So the answer is, of course, if we have a good innovative sector in the country, besides attracting the clinical trials from outside, we are going to have, on top of it, the clinical trials for our Brazilian companies. But remember that we will do that if the doing clinical trials in the country is as competitive as doing outside. So if I take 9 months to get an approval in Brazil, where I'm going to do it? I'm going to do in Singapore, in I don't know, in
Mexico.
US, wherever.
Yeah.
You know, it's a global chain. And what we have to understand is that when you go to this world, the time you have to recover, and everything comes to that at the end, the time you have to recover your investment is critical. I cannot lose it in months of ethical approval, in bureaucracy, in customs to import, export stuff, and in the supply chain of development is international. We cannot use only resources in Brazil. But the point that I want to make is that the real value at the end of an innovation is exactly the patent and the protection of your asset. That's the value that the country carries. And as much as we have that, the better we go with the sector. I have already stated that in other congresses, that I think that we have an opportunity in Brazil to do with the pharmaceutical sector what we did with agriculture, with oil and gas, and with aviation. I do think we have this possibility. We have strong companies with very good cash generation and the desire in some of them to do the move. So yes, the clinical trials will be reinforced, but the very strong point here is how we improve the whole aspect of innovation in the country.
Just quick comment, Luis. A lot of the multinational companies are investing a lot in clinical research. In the old days, they used to do phase 3 or phase 4. Today, there are companies doing phase 2 and phase 1. There are, due to the challenges of our healthcare sector, there's quite a few companies actually investing in phase 1 trials, or doing quite good research, because we have very good hospitals, very good academia, very good brains actually. So we have the manpower to do it. So it will be a shame for Brazil if we lose this opportunity here to protect that specific knowledge that we are building. That's why regulatory data protection, I would say, is the key to protect the work of the researchers in Brazil.
Well,
I could
yes.
really fast chime in on that.
Yes.
The specific data package exclusivity, regulatory data package protection, actually is protecting what is submitted at the end of the dossier to get the approval. And so the fact of doing clinical trials within the country, well, that has a derivative effect on when will a company file their regulatory package in Brazil. And as Martha had pointed out, Fabio pointed out, it's multifaceted. Now, there is actually hard data that in that Interpat study on the benefit of IP to the Brazilian economy, it actually shows there is a correlation that when patents are strong, data package exclusivity is there, then you do see companies will start doing more clinical trials in Brazil. So, well, in whatever country has these aspects of IP. So it's not an exact direct effect, but it is a clear derivative effect.
Oh, thank you, Craig. Yeah, indeed. And going back to your presentation, Craig, it seems to me that Brazil, in this aspect of the regulatory data protection, is not aligned with most of the countries. In fact, the vast majority of countries have this protection, probably because it's positive, because it's worth having this protection. It encourages the R&D, it encourages the clinical trials in the country and so forth. And perhaps the last, we are almost, it's almost our time, 12:30 already, but in the meantime, we are now it seems they all agree that the subject, the topic is much more mature, as Fabiano said. Either perhaps the generics and the R&D industry, foreign industry, all agree that data protection is important. And for that, we need to have a strong legal framework. But in the meantime, and this is a personal opinion, to me, it seems that we have so far protection for unfair competition. So for those who ask what to do in the meantime, while, I don't know, the law 10,603 is not amended, if necessary, what do we do with Article 195, Section 14? Because it is applicable. So the way out that we see and that we are trying to have recognized before our courts, and we also hope that our courts can listen to us, is to apply, is to avoid this, so to say, unfair competition, and to decide on a fair time frame for this protection in the meantime, whether it is 10, 8, or 5, but it's better to have it and not than not. So since it's 12:32, and thank you so much, Craig, Marta, Fabiano, for the rich presentations. We learned a lot today with you, and so thank you so much, and thanks for everyone that watched us. Okay.
Thank you.
Thank you.
Bye-bye. Bye-bye.
Have a great rest of your day.
Bye all.
Bye.
Bye-bye.